Go on the record in the matter 26 CF 07, State of Wisconsin versus Jose Chevaria. Appearances are we have the state appearing through Jose Vila in person. Mr. Chevaria appears in person with counsel Amber Sherwood. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Ms. Sherwood, can you please recite it for the record?
Yes, Your Honor. The offer would be to dismiss and read in count 1, strangulation, plead guilty to the battery domestic.
This Wisconsin courtroom hearing starts like a routine plea deal, but within minutes, it turns into one of the most unexpectedly emotional and chaotic sentencing hearings you'll see all year. A domestic battery case between brothers, allegations of strangulation, repeated trips to court, and a defendant trying to convince the judge this was just wrestling. But here's the twist. Instead of throwing the book at him, the judge begins questioning whether jail time will actually solve anything at all. Add in family drama, substance abuse concerns, and a courtroom exchange that swings between tension, humor, and frustration, and you've got a case that feels more like a family intervention than a criminal sentencing. Stay locked in, because this hearing takes several turns nobody saw coming.
Abuse for 60 days incarceration, and to plead guilty to count 3, disorderly conduct for costs only.
Now, what's his jail credit?
His jail credit is 16 days.
So he's looking at going to jail?
Yes, Your Honor.
Okay. Mr. Chevaria, that's the agreement that you've reached?
Yeah, that I guess sentence the 2 months or whatever. That's
Yes. But you only have 16 days of credit, so you would need to serve additional dates or additional time?
Mm-hmm.
And you understand that?
I understand that, yeah.
Okay. And that's what you're wishing to reach, the agreement?
Yeah. Do you guys sometimes do give somebody a little bit of time so I could take care of a few things? All right, cool. Yeah, then I'm doing that, yeah.
Okay. So I have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Mm-hmm. Yes.
Did your attorney go over the document with you thoroughly?
Yes.
Essentially word for word?
Yep.
And you understand everything completely?
Yeah.
Is that your signature on the second page?
Yep.
You're pleading guilty to count 2 and count 3. And Ms. Sherwood, are they both going to continue to have the modifier?
Oh man.
I guess I do not know that, Your Honor. It wasn't
I think
specified.
it would be, one's going to have the modifier, so if you remove the other one, it just makes it cheaper with less surcharge.
Yeah, that's fine, Your Honor.
Okay. So the disorderly conduct, remove the modifier, Mr. Vila?
Yes, Your Honor.
Granted. So you're pleading guilty to 1 count of battery with the domestic abuse modifier and 1 straight count of disorderly conduct. You're 35, you have 10 years of schooling, but you can read, write, you understand the English language, all correct?
Yep.
Did your attorney thoroughly go over your constitutional rights with you?
Oh yeah, she did.
And you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Do you understand that you're pleading guilty to count 2 misdemeanor battery with the domestic abuse modifier that the state would have to prove on or around January 2nd, 2026 in Burnett County, Wisconsin, you caused bodily harm to MT by an act done with intent to cause bodily harm to that person without that person's consent, and that person has a domestic type defined relationship with you. Do you understand what the state would have to prove?
Yeah.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both? Plus, because of the domestic abuse modifier, it would have an additional $100 surcharge, and it could be the federal prohibition to no longer being able to use or possess a firearm for life.
Yeah, I got it. Yeah.
Do you understand with count 3, disorderly conduct, the state would have to prove that same date, time, and place you engaged in either abusive, violent, or unreasonably loud or otherwise disorderly conduct, which tended to provoke a disturbance. Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both.
Yes.
Do you understand that I'm not bound to follow the agreement that's been reached? That is, I could sentence you all the way to the maximum possible penalty for each of these offenses if I thought it was warranted.
Yes, I understand that.
Do you still wish to proceed and enter guilty pleas?
Yes.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, that section called the probable cause section, where it basically says what happened and why you were charged with these crimes?
Oh, yeah.
For the most part, are those facts accurate?
Yeah.
Are you admitting here today that you in fact did engage in battery and disorderly conduct?
Can I say something with that too?
You'll get an
Okay, my
opportunity.
bad.
yeah.
Yeah.
And are you pleading guilty because you are guilty?
Yeah.
Ms. Sherwood, may the court use the probable cause section of the criminal complaint to find a factual basis?
You may.
Has anyone made any threats or promises to you for you to plead guilty
No.
today? You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yeah.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
She answered all of your questions?
Yeah.
You're satisfied with her services?
Yeah.
Any questions for the court or your attorney before I proceed?
No.
As to count 2, battery with a domestic abuse modifier, how do you wish to plead?
Guilty.
As to count 3, disorderly conduct without the modifier, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 counts. Count 1 will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. At this point, the court is quite familiar with Mr. Chevaria at this point in time. He's been in and out in front of this court for numerous disorderly conduct convictions in the last 5 years alone. This is a case that stemmed from a verbal altercation that escalated into a physical fight, resulting in, bruising on the victim's neck and some destruction of personal property, namely the necklace here. With that in mind, and after receiving victim input on this matter, I think the joint recommendation is appropriate. While Mr. Chevaria is here taking responsibility for his actions, this sentence is necessarily just a punishment for what happened. There's really no other way to spend that one, and making the victim whole by doing the stipulation for the restitution for the property that was broken. With that, all of those factors kind of taken into consideration, I would ask the court to adopt this. Thank you.
Thank you. Okay, Ms. Sherwood.
Yes, Your Honor. I do want to put on the record, we have stipulated to $100 in restitution for the broken necklace. Mr. Chevaria is here taking responsibility. He is doing so in relatively short order, Your Honor. This is not dragged on. This was an unfortunate fight and argument that happened between 2 brothers. Should it have happened the way it did? No, it should not have, and Mr. Chevaria is aware of that. However, he is here to take responsibility. Him and his brother have quashed, for the most part, what is happening in a way that they can. Their family, they understand. Mr. Chevaria's brother does not want more than what is being offered currently. And for that, Your Honor, we are asking that you follow the recommendation. He is going to be punished. He is going to be sitting, as Your Honor pointed out, more time in jail than he has already sat for this, along with a pretty hefty monetary fine, Your Honor. Thank you.
All right, Mr. Chevaria, anything you want to say, you want to let me know?
Oh yeah. I just want to say that it wasn't bad like that. Battery, you guys, like, come on, what I mean? We did wrestle, what I mean? Throw each other around, but there was like no punch or nothing like that to where it got really serious. It's just always pushing with us, But yeah,
And it gets to the point of
it was
calling law enforcement.
Yeah. Well, mom gets like that too. When she gets scared that we're really gonna, throw a fist or something. So she's always quick to call the cops. But for real, yeah, no, there was no punch or nothing like that. We were still standing when they got there. It was on the ground or nothing like that. It's really just, a feud of a stepbrother and a brother. Just sometimes
Live together in tight quarters.
Yeah, and that, yeah. Stop
I'm-
looking at me.
that
Yeah, that's right.
consume either alcoholic or other substances that it gets heated
Yeah,
and the family wants it stopped.
yeah.
This isn't their first time here. It's not your first rodeo in the
Yeah,
court, and it's
yeah,
not
yeah.
your first rodeo with your stepbrother and or your brothers, or,
Yeah.
you know, you've been here before.
Yeah,
Mr.
yeah.
Chevaria, I don't know how to calm things down in your house. I don't necessarily know if like a lot of jail time, I don't know what that's gonna do, honestly. It's just for punishment.
Yeah, for real. Just,
I don't even know if your brother wants you to sit 60 days in jail, or if it was reversed, if you would ask the same.
yeah.
I wish you boys would settle down
I know.
or find a job and move out.
Yeah. Yeah, I'm working on that too. Yeah, okay.
Because I'm sure your dad's getting kind of annoyed coming to court too.
I know. Yeah.
He is here almost every single time
Yeah.
supporting you.
Yeah, a little sissy fight it was, just a sissy wrestling match, you know. Yeah, that's what it was.
And I'm gonna guess, well, it was January 2nd, so not long after New Year's. So
Yeah. Oh,
what
yeah.
could have happened there?
Oh, yeah.
Well, Mr. Chevaria, you are willing to accept punishment. In a case like this, I'm not really sure what the punishment should be. Should it be 60 days? It seems excessive, but the attorneys there are the ones that are reaching the agreement. But I've said this before, I don't want to see you in here again, Mr.
I
Chevaria.
know. Hey, it hasn't been for nothing bad though, you know what I'm talking about? Like how I was bad back in the day,
You were-
I was betting on stuff like that. So, you know, I mean, I haven't had any drug charges or anything like that, you know. I quit that when my brother passed away, so.
I know that's the positive thing,
Yeah.
that you haven't, I mean, the argument of strangulation, suffocation,
That sounds bad.
it makes it sound a lot worse.
Yeah, it does.
And it was with your brother, and so I understand your I think I have an understanding of your sibling rivalry fights.
Yeah.
What I'm gonna do is, I just know your history, and this isn't as serious as it looks in black and white. I'm gonna sentence you to 35 days in jail. I'm not doing 60. I don't think anything more than 35 is necessary.
All right.
You have 30 days to figure it out and to report.
Okay.
You have 16 days of jail credit.
Mhm.
$100 for the chain for your brother. I'm gonna tell you, you better get that paid, and you better get
Yeah.
it paid off quickly.
So how would I go about paying that? Do I just give him the money, take a picture and send it to you guys, or how do I do it? Or just send the money up here?
Has to be paid now to the clerk.
Oh, okay. I can't just give it around on the streets like that?
You gotta give it to the clerk.
Wow.
Now that it's went through this process, had you have paid him prior to and got confirmation to the state, then they could have said, and the
Ah, man,
restitution's
because I
already
did
been
say
paid.
something. I said something to him a couple days ago too. Dang. All
So
right.
it's gonna need to be paid here, and I'm gonna say that you have 30 days to pay that.
All right, cool. That sounds good. Thank
Okay.
you. Yeah.
I'm only gonna assess $200 in the DNA surcharge. I'm waiving and that's for each count, plus a $100 surcharge for the battery because it has the domestic. I'm waiving all of the other court costs and fees. It's already gonna cost you $500 for surcharges and the $100 for the restitution. I need payments of, are you paying other fines and fees? Okay, well, this one you're gonna start paying, and I'm gonna
I
monitor
got you.
that.
Yeah.
$75 a month. If you fail to pay, I will issue a warrant. You could sit up to 6 months in jail, so you have to start
Okay.
paying this.
Yeah.
First month will be due in June. I'll give you a month off
Okay, June, all right.
because you have to pay that restitution, but you have to make at least $75 a month or a warrant will be issued.
Okay.
Could sit up to 6 months and the civil judgment will be entered against you. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Again, 16 days of jail credit, federal prohibition. If they enforce it, no longer able to use or possess a firearm for life. You're already a felon though, so that really doesn't matter. I just have to say that. I think that covers everything, Mr. Vila.
I would agree, Your Honor.
Sure would.
Nothing from us, Your Honor.
Good luck, Mr. Chevaria. Just be kinder and gentler. And I know I said this before, and this, I don't know if it was with the argument with this brother or the other brother or a different
Oh, that
brother,
sounds bad.
but stop, just walk out.
I know. My pride, man, because, you know, Spanish people, you know, so.
Your pride's taking you
I
to
know,
jail.
I know. Yeah.
So stop.
Yeah. But I am
Alright.
doing good though. I'm not, you know, I'm not doing anything illegal, so.
That's good. All right, so I need your DNA. You're gonna need to make sure that the jail has that, but you can either do it now or wait until you report. But again, 30 days to report. If you don't report in 30 days, escape charges can be entered, can be charged. 30 days, okay? Thank you. We're adjourned. Thank you, Your Honor.
Thank you, Judge.
Senior Chevaria, it's okay if you send him to his room. We will go on the record in the matter 26 CM 48, State of Wisconsin versus Cody Mason. The state appears through Assistant District Attorney Jose Vila by video conferencing. We have Amber Sherwood making a special appearance for Joel Feliski. For Mr. Mason, Mr. Mason appears in person. We're set today in this matter for an initial appearance. Ms. Sherwood, did either yourself or Mr. Feliski go over the criminal complaint with Mr. Mason?
Yes, Your Honor, we have. He understands the charges and the maximum possible penalties. We waive the reading at this time and plead not guilty.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Are you on P.O. Box? Is it your mailing address, P.O. Box 134?
Yes, but I don't have a key to that PO box. She has both keys.
Okay. Do you have the ability to get mail anywhere?
No, I do not.
Okay. Where are you currently staying?
On the streets and at the lodge. I did a bunch of work over at the shops just to get 3 nights in a hotel room. I went from 21 days in jail to homeless.
Well, I'm gonna guess that there is an offer, correct, Mr. Vila?
No, Your Honor, I don't have an offer on this file from the notes I have on hand.
Okay. So what is we're in victims' rights compliance?
Yes, Your Honor.
Is victim continuing to ask for no contact?
At this time.
Okay. Well, hopefully you'll be able to get your mail. You should be able to get your mail even without the key. You just have to prove who you are and that's your box.
Okay, well, I can walk and talk to him.
So
Yeah.
you should be able to get your mail. And I'm just saying that just because of the notices and those kinds of things. Does your telephone number end in 0365?
Yes, ma'am.
Okay. May we send you text message notifications?
Yes.
We need to get this matter set for another status and hopefully it can be something sooner rather than later so that, you know, we can see what an offer is and what it would take for you to get this matter moving.
Your Honor, we're asking for sometime after the 5th. He has decided to start classes with Dave Hatch. He starts that tomorrow. He says his last class, as long as he can finish paying, would be May 5th.
I'm hoping to get it all set up and have all 4 classes done with him by the May 5th, or my last one on May 5th, so I can cash my check, get my count back from negative to positive, and be able to get to Dave Hatch and pay the $150.
Excellent. You are on the ball.
I'm trying not to slack. My boots are made for walking. That's what they'll do.
Well, like
I walked all the way up here from town.
Can Mr. Feliski do May 7th?
He is not in town that entire week,
Yeah,
Your
I
Honor.
need some conference or something.
Trial skills, yes, Your Honor.
Yeah. The next available time I could do would be June 1st at 1:15.
Does that work for you?
Can I ask one thing?
Yes.
Is there, if I get all 4 classes done with Dave Hatch, is there any way we can get this lifted where I can talk to my kids? My kids' birthdays are coming up, all within
How
June and
old are your
July.
kids?
9, and it's my son's golden birthday this year.
And I'm gonna
My other
guess,
one's 8, my other one's 5, my other one's 2, and all of their birthdays are in June and July.
I'm gonna guess that you need to call her to be able to talk to them because they don't have a phone. There is a way, Mr. Felisky, you're gonna have to talk to Mr. Felisky. Once you're done with your classes, and then we get victim input on whether or not she's okay with you calling and at least having that kind of contact or where we go from there. Ms. Bauer will be in contact. That's what she does. She's a victim witness coordinator. She'll be in contact with the victim. Mr. Felisky, you'll stay in contact with him. You'll give him proof that you've completed that course, and he will make sure that Ms. Bauer and Mr. Schmidt have a copy of that.
I'm not gonna slack, gonna get it done.
And it can be done if it's all agreed upon and we don't need a hearing, it can be done without writing to amend that bond condition. Okay, so just do what you need to do and get those things to Mr. Felisky so he can get them to Ms. Bauer and Mr. Schmidt. All right,
Understood.
okay. So can he do June 1st at 1:15?
Yes, Your Honor.
All right, June 1st, 1:15, we'll set that for your status conference. But again, once you get all that stuff, it can be amended. Okay, well, I can't guarantee that. We have to have victim input.
Okay.
Okay, all right. Anything else, Mr. Vila?
No, Your Honor.
Ms. Sherwood?
No, Your Honor.
All right, then we are adjourned. I do not have Ramirez Viorado.
I'm just gonna go check to make sure he's not sitting outside, Your Honor.
We will go on the record in the matter 26 CM34, State of Wisconsin versus Benjamin Baker. The state appears through Assistant District Attorney Jose Vila by video conferencing. We have Mr. Baker appearing in person. His counsel, Charlene Perrin, is appearing by video conferencing. We're set here today in this matter for a return on warrant initial appearance arraignment. Warrant is quashed. Ms. Perrin, were you able to go over that criminal complaint with Mr. Baker?
I was not. I haven't been able to talk to him yet. I wondered if perhaps we might be able to have a hearing on the 4th when I'm there.
Just give me 1 second. Just give me 1 second. This is a Mr. Schmidt case, Mr. Vila, but has he directed you to provide an offer today?
I've had one.
Oh, you have one?
I have one, and I think it's possible we could resolve it on the 4th if the court would entertain having a hearing then.
On the 4th. Oh, man, I've already double, triple booked everything on top of our sentences. So if it'll be something short and quick, we certainly can do that because, you know, we've had to throw in, thank you, Ms. Perrin, for taking the Spanish interpreting client. And we had to place him on top of your first plea or your first sentencing in the morning. And then we've had to place a couple other things before your second hearing, your second sentencing in the afternoon. Do you think that this is going to be something that can be more quick than not?
I do, but I'm also there for another sentencing on another day. If that would be better.
We can move it to the 4th. I'm just trying to see what would probably be the easiest. Probably 1:30 right before Mr. Avery. We'll call this case and then we'll move on to Mr. Avery Weaver's matter at 1:30.
Okay.
Okay, so we're gonna move it to May 4th at 1:30. You can come up here and get the notice, okay? And then make sure you be in contact with your attorney. Does your I don't have a telephone number. What is your attorney? What is your number?
Mine,
Yes.
715-431-0000. 0962.
0962. Did you get that, Ms. Perrin?
I did, and I will call you tomorrow. Okay?
Sounds good.
Okay,
Okay.
thank you.
Thank you.
Okay. The Zoom user, is that Mr. Anderson?
It is, Judge.
Okay. Stephen Nelson? Are you okay, sir? Take your time and just come on up. And generally, I would say that attire is not appropriate for court. I understand your condition, so you're okay.
Because I just got out of surgery on Monday.
Yeah, I know, and that's because I know that you knew that you were saying
I
you
don't
were
usually-
having surgery. So
I
I'm
don't-
just letting you know
All right,
that I
thanks.
understand why.
Thank you.
All right, we will go on the record in 26 CM 43, State of Wisconsin versus Stephen Nelson. The state appears through Assistant District Attorney Jose Vila by video conferencing. Mr. Nelson appears in person with his attorney appearing, at least right now, it's by video conferencing capability. I've now asked him to start the video. We're set for an initial appearance. Mr. Anderson, were you able to go over the criminal complaint with Mr. Nelson?
Yes,
He understands the charge, the maximum penalty,
he does.
formal reading or waive.
Waive any further reading.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. And this is a Mr. Schmidt. How long is your recovery? I know that it'll take some time, but I know the first few
4
weeks.
weeks, I think, before I can move my arm.
How about your June 1st at 9 a.m. date, Mr. Anderson? June 1st at 9?
That works.
All right, you can come up and get your notice and you're free to go.
All right.
Or you can come up. Yeah, I was wondering if it was going to be difficult for you. Do you have any other cases, Mr. Anderson, or is that your only one?
I do not. Just want to make sure he gets his notice and leaves.
Okay, thank you.
Thank you. Everyone have a good day.
You too. Ms. Sherwood? Do you have anybody? Mr. Harmon had Mr. Harrington.
He does, but I didn't know if Mr. Harrington would be showing up. He is not.
I don't think he's not in this case or on this case yet. So the PD, I don't know, is Mr. Harmon gonna have to call your office, blah, blah, blah?
No, he does not. He already qualifies, Your Honor.
Okay,
So I can make a special appearance.
so Mr. Harrington will be added to this case as well.
Yes.
We'll go on the record in the matter 26 CM 47, State of Wisconsin versus Evan Harmon. The state appears through Assistant District Attorney Jose Vila by video conferencing. We have Amber Sherwood making a special appearance on Mr. Harmon's behalf. He has Mr. Eugene Harrington for other matters, and that this will be added to his case list. But for the meantime, Ms. Sherwood is making a special appearance. Mr. Harmon appears in person. Ms. Sherwood, were you able to go over the criminal complaint with Mr. Harmon?
Yes, Your Honor.
He understands the charges and the maximum penalties.
He does. We waive the formal reading and plead not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Let's go ahead and get this scheduled. Thank you. June 15th at 1 p.m. June 15th at 1 p.m. You're currently set for a plea and sentencing. I'm going to strongly encourage you to call Mr. Harrington. I don't know if he knows about this case. He will shortly, but talk to him. And then he's going to need to be in contact with the district attorney's office to see if the offer has changed or what's going to need to happen. Okay.
Yes, ma'am.
All right. Thank you.
Thank you.
We are adjourned. Anyone else, Ms. Sherwood?
Not for the 1 o'clock, Your Honor.
Mr. Dung? No, you're not Mr. Duncan. You're not Mr. Bremer. Jaden Johnson. All right, Mr. Johnson. Were you going to apply for a public defender?
He did, Your Honor. He does not
He does not qualify. Okay, you can come on up here.
Sorry, because it was already scheduled.
Mr. Vila and Corey and Olivia, it's been, Ryan Lockach has been added to the case, 26 GF 89 for a bail request. We'll do him after Mr. Johnson. We will go on the record in the matter 26 CM 36, State of Wisconsin versus Jaden Johnson. The state appears through Assistant District Attorney Jose Vila by video conferencing. Mr. Johnson appears in person without counsel. He applied for a public defender. He does not qualify. Mr. Johnson, did Ms. Sherwood go over with you the ins and the outs of seeking a court-appointed attorney?
Yes, she did, yeah.
So you would have the ability to do that, to apply for a court-appointed attorney at your cost. It's $100 an hour, but that's a lot less than what they usually charge, $300-400 an hour. Same private attorneys, same experienced private attorneys. They just agree to take it for a lesser cost for pro bono or to help, you know, people out kind of deal. So if that's what you wish to do, I would need you to fill out that application before you leave here today. And so it's not a very intrusive or extensive process. So if you can just fill that out, because are you going to be seeking an attorney?
Yes, I would, ma'am.
That's great. That's good to know. So get that filled out, and then I can set this for an adjourned arraignment date. We call it initial appearance, but it's really an arraignment with the misdemeanors, where you would enter a not guilty plea and we would move on from there. And I can set it on somebody's calendar. I need to see if there are, who the victim is for conflict purposes. Yes. I don't have a victim list. I need to know for conflict purposes.
I don't have the victim in the case.
There's not a victim. It's a battery.
Didn't ping me.
May I speak?
You may, but don't say anything against your interest because it could be used against you.
Okay. He's not even, he's in New York.
Okay.
He-
All right. Okay. Well, there is one, but he's not cooperating or not a part of this.
Your Honor,
Okay.
if I may, there is an offer that I can extend to Mr. Johnson if he wants to contemplate that at this time.
Okay, go ahead.
It's simply to take an anger management class and plead to the DC for court cost only. That's it.
All right. So do you understand what that means? And so we have, there's an anger management type of course that is offered here through Burnett County Restorative Justice. I think it's a 4-week course. And it's $150, and the offer is to take this class and then plead to the disorderly conduct misdemeanor for court costs only. So you can contemplate that and decide if that's what you, if you wish to accept that. I don't really want to put you on the spot right now, simply because I want you to have time to think about that, because if you want, once you get an attorney, then you're going to, and if, let's say you want to accept the offer, then you're going to have dual expenses, paying the attorney and paying this and all of those things. So I want you to be able to think about all of that. So I'm not going to require you to fill that out right now, because once you fill that out, then it's, unless you say, keep it on record, but right now I don't want an attorney, I want to think about that. If that's what you want to do, we can do that. I just don't want you to get bound with being unable to then yourself talk to the district attorney's office. Okay. So do you want to fill that out and file it and then have the court wait on an attorney?
If, well, I guess, if, I did the anger management, would that make it so that charge wouldn't be on my record?
Well, the battery wouldn't, the disorderly conduct would, with this offer that the state is presenting.
Okay.
So it sounds like you want to think about things. What I'm going to do is I'm just going to give you a quicker turnaround and adjourn this date. And I'm going to give you this form. It says domestic violence. It should say domestic violence / anger management. They're similar, but yet slightly different. And if you want to think about this, you can do this. If you decide you want an attorney, then you'll file that, turn that in on this next date, and then we'll know how to maneuver and go around it, okay? April 30th at 2:30, April 30th at 2:30. So you can come get this and your notice, and I'll see you next week, okay? Oh, sorry, an updated address. Are you still on Highway 63?
Yes, sir.
And that's West 4384?
No.
What is the address?
It is still Highway 63. That's for W39.
Okay, and does your telephone end in 4171?
Yes.
Excellent. May we send you text messages? Thank you. Okay, thank you.
And I can get you your notice.
Yeah, if you come up here, she'll print you your notice so you have that. We do not have Joshua Bremer. Mr. Locke, is that you? I can't hear you or see you, but I guess that is
Yes,
you.
Your Honor.
Okay,
Can you hear me?
I can. Is there a button for you to be able
Says
to
start my
push?
video. Should I hit that?
Yes, please hit that.
All right. I see myself.
Okay, I swear that you were put on this I might have to refresh.
GF.
Yeah, I can't pull it up on my computer. Oh, there we go. Okay. There we go. All right. We'll go on the record in the matter 26 GF89 group file of Ryan Lockach. Appearances are we have the Assistant District Attorney appearing by video conferencing. We have Mr. Lockach appearing by video with approval of the in custody in Burnett County Jail. Mr. Lockach was arrested a couple days ago. Bail was set at $500 cash with certain conditions. And then Mr. Lockach, I received your letter here today requesting that the court consider lowering that to $250. And in that letter, you say that you promise you'll do, you say, I promise that I will do right. You won't see me back here except for court. And so you're pleading with the court to lower that and to trust you that you're going to make your court appearances and engage in this process. Is that correct?
Yes, Your Honor. See, I've never missed court ever, and I had a I had an interview today for a job that is in walking distance from where I'm living in Spooner, and I was not able to make that today, but I was hoping to get out so that I was able to call them today back and say, hey, I'm sorry about the communication, but I'm very, very interested in that job. Is there a chance that I can still get it? Because I've been looking for work and it's been tough.
I hear you, Mr. Locke, and I don't want to interfere with your ability to get a job and to be able
Yes.
to provide for yourself, et cetera, because everybody deserves to do that and you should be able to do that. And you said it's within walking distance from your address?
Yes, it is.
So what is your address then?
It is 613 Smith Street in Spooner.
Okay. And is this a bar or restaurant or anything that I would have to worry about with bond conditions?
No. It is for a warehouse. It's tenant, TENT or something, TENENT or something. It's spelled.
Okay.
So I'm
All right.
really hoping that I get that job because it's perfect for me. It's like right down the road. There's no reason why I can't make the job because it's walking distance, and then I'll be able to figure out my license and everything. So, but right now I don't have any money, and that's why I didn't know that there could be, because Wisconsin is so different than it is in Minnesota, because you have to in Minnesota you got to find like a bail bondsman. See, I didn't know that there could be a signature bond to where you don't have to pay anything to get out. So that would be awesome if I wouldn't have to pay anything, because I can't even afford anything right now. That's why I was hoping to get a job so that I was able to,
Well, Mr. Locke, the reason why the court put cash on as bail in this
Yes.
case is because you have the open Polk County case. And in this new incident, that would be allegations that you violated your conditions of the Polk County bail.
Yes.
So then that raises concern for this court that, are you going to make your court appearances? Are you going to follow the court's conditions, et cetera? So are you telling me here today that you're promising in open court here, you're going to, if charges are filed, you're going to abide by that and you're going to come to court? And I may allow Zoom too, because especially if you don't have a driver's license, I
Yes.
don't want you to drive if you don't have a license. And quite honestly, I want you to get your driver's license.
Thank you.
And I want to give you time to do that if that's something that we're
Thank
going to
you.
deal with in my case. And so
Yes.
I will do that. I'll let you know that.
Thank you.
So if you're telling the court and you are telling me the truth,
Yes, I promise.
okay, then what I will do is, because I don't want to stand in the way of a job and getting a driver's license, etc. Well,
Thank
first,
you so
can the
much.
does the state want to make any statement, any argument?
State has no position on this, Your Honor.
Okay, so I'm going to believe you here,
Thank
okay,
you
Mr.
so
Locke?
much.
And I'm going to trust you. And I'm
Yeah.
going to tell you, if I extend trust and you violate it, then I'm not as nicey, okay?
I appreciate it so much.
So I will amend to a signature bond. You don't have to
Thank
come
you.
up with any cash, because I'd rather have you save that. Even you said $250. I'd rather have you save that and work towards your driver's license, rent, food, whatever. So it'll be a signature bond, and you just have to follow the conditions of your Polk County case and make your court appearances here, and don't commit any other crimes or do those things that are written on your bond, okay?
Yes, I promise you. Thank
All
you
right.
so much.
Okay, so now we have your address, and did I ask for a telephone number? Yes, I did. I think, did I?
Is it 763-237 4394?
4394 763-237. Let me see, 4394.
Correct.
Yep, we have that. We're good to go.
Okay.
Okay, Mr. Locke, thank you. Let me see, you are currently set right now for May 2nd.
May 2nd? I thought it was the 6th.
Oh, sorry, you're right, May 6th.
Okay.
See, you're smart, you're paying attention. I'm glad to hear that. May 6th at 2, May 6th at 2. And I'm gonna tell you, because I'm extending you this trust,
Yep.
if you want to appear by video conferencing at that time, because it'll be an arraignment, I don't want you to have to miss too much work. You can do that, okay?
Thank you. Thank you. I appreciate it.
And you're gonna cooperate with the court. You're gonna try and see about getting these matters resolved one way or another, even if it has to go to trial, all of those things.
Yes.
Okay, all right. So then we'll see you May 6th at 2 p.m. The video conferencing will be on your notice, and you should get that before you're able to leave the jail today, okay?
Thank you so much, Your Honor. I
All
appreciate
right,
it.
thank you, Mr. Locke.
You have a good day.
You too.
What started as a straightforward plea hearing evolved into a revealing look at how judges navigate messy, real-world situations where family conflict, addiction concerns, financial hardship, and criminal accountability all collide. In the Chevaria case, the court ultimately rejected the harsher negotiated sentence and imposed 35 days instead of 60, while still ordering restitution, financial monitoring, and strict reporting requirements. Throughout the hearing, the judge repeatedly emphasized one thing: this courtroom has seen this family before, and the real goal now is preventing another return trip through the system. And beyond that first case, the rest of the docket painted an even bigger picture of modern criminal court. Defendants struggling with homelessness, finances, addiction recovery, transportation issues, and family separation, all while trying to navigate the legal system in real time. Some were offered second chances. Others were warned that trust from the court only goes so far. If you found this courtroom breakdown fascinating, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, legal analysis, and real-life justice moments you won't believe actually happened.